Hi, my name is Eric Olson. I've been an attorney for 40 years and the director of HelpsNet. Help seniors protect them from collector harassment and help them maintain their financial independence. So this video is going to briefly talk about, is a senior's car at risk from creditors or collectors? A question we sometimes get here at Helps. So first, we want to talk about a senior that has a car that is secured by a loan they have on the car, where the lender or the person to whom they owe money is on the title as the owner, and the senior is the registered owner on the but doesn't have the title to the car. In those instances, if you do not make the car payment, the lender can repossess the car. Usually that won't take place till probably 30 to 60 days at least after you stop making payments, unless it's a brand new loan or you've given the collector or the creditor a reason to suspect that you're not going to pay the loan, or if they called you on the phone and said you didn't have the money and you weren't going to be able to pay it, then in that event they may speed things up to repossess the car. On occasion, they choose not to repossess a car. If the car is really old, not worth a whole lot, they might just not bother to do it. Don't count on that, but that's a possibility. Now, why would they not do that? Because it costs money to repossess a car. They have to hire someone to do it. And especially if it's an older car, they're going to have to pay someone, and they might decide it's not economical for them to do it. Now, the real question is, if you own a car that's free and clear, can a collector or creditor repossess the car? Well, highly, highly unlikely. And that I'll give the scenario. Before anyone would have a right to come after any of your personal property like a car, first they would have to sue you and get a judgment. You'd have to be served papers. You owe the money, not do anything about it, they get a judgment. And let's say they got a judgment for $10,000. And let's say you have a car that's worth $10,000 and it's free and clear. Well, every single state has what's called an exemption, which is the amount of equity you could have in certain property and protect it from creditors. And normally that's related to when a person files bankruptcy, but it also applies outside the bankruptcy field. So if a person was in a state where their exemption for a motor vehicle was $2,500 and the car was worth $10,000, then they would have an equity in the car over and above the exemption of $7,500. Then the question is, will a judgment creditor come after the car? In over 40 years of practice, I've seen that happen maybe 2 or 3 times, if that. And if I remember right, it's been one particular collection agency. It just, practically speaking, it just doesn't happen. Okay, it's possible, but it just doesn't happen. It's almost like thinking, well, if I drive on the road, am I going to get in an accident tomorrow at 10 p.m.? Well, I suppose it's possible, but the odds are it won't happen. And it's the same thing with excess equity in a car. A creditor gets a judgment coming to take your car. Now, why wouldn't they do it? Well, because they have to go through certain legal procedures. It's not like a repossession for a car where it's a car lender. They'd have to get a writ of assistance from a sheriff. They'd have to post a bond and go through a specific legal proceeding that's complicated and expensive. And in the meantime, if the person filed a bankruptcy to protect the car, they want to get it. So they've learned by the law of hard knocks that it's just not worth it for them to do that. So for you to worry about your car being repossessed if you've got some non-equity in it, no. But what disappoints me sometimes is there's a lot of articles on the internet by attorneys that talk about that and act like that's something that is realistically going to happen, when in fact it's not realistic. There is one thing that's called the law, and the other thing is called the real world. And sometimes there is a complete difference between the two. So hopefully that will give you some insight. But generally, it would be nothing to worry about in that kind of situation. If you're a senior and you have old debt you can't afford to pay, and you're being harassed by collectors, and you receive protected income like Social Security, pension, or disability or VA benefits, that income is protected. You very well don't need to file bankruptcy or can't afford to file bankruptcy. And what HELPS does is we represent seniors as their attorney under the Fair Debt Collection Practices Act in order to stop collector harassment. And we don't turn anyone away that needs our help. The cost is either free or very minimal. So look at our website, www.helpsishere.org, or call us toll free at 855-435-7787 and continue to look at our YouTube videos with questions that you might have. Have a great day.